This is Professor Wes Porter, and again today we're talking about the rules of evidence, in particular hearsay. We've talked in other videos and other times about definitional hearsay, and the most important definition that you'll learn in law school: statement that's out of court, that's offered for the truth of the matter asserted. And we know that this definition belongs to the opponent. The opponent who objects during trial, objection, hearsay, embraces these three, goes to sidebar and says this is an out of court statement. This is actually a statement that was some assertion, whether written, verbal, or by conduct by a human, and it's offered by the proponent. It's offered by the person serving it up at trial for the truth of the matter asserted. And we now understand that that's where the fight is, that we're going to argue about this good purpose, bad purpose. That by objecting as the opponent, we're saying that the proponent has a bad purpose here, that they are offering it for the truth, the actual to prove what it is. And we know from other videos that we can argue about the definition. Over here on the left-hand side, the proponent can say in their response, it's not a statement, or it's not offered out of court, or most likely that the proponent, they're not offering it for the truth of the matter asserted, that they have some other reason. We've talked about some of the other reasons that we can offer, namely Porter's top 5. Today we're moving on to the second column here, and this is when the rules offer a not hearsay definition. That is, the proponent has their own definition, their own foundational requirements that they can rely on under 801D. And we're first, this area in red today, talking about statements offered against party, or statements by party opponents. I want you to focus on the title of these: statements offered against parties or statements by party opponents. You'll hear a terrible title used for these called admissions sometimes. I don't want you to use the word admissions, and I don't want you to react to the word admissions, because it leads us to bad results. It leads people learning the rules and young attorneys to think that a declarant has to admit something, or a party has to admit something. They don't. They simply have to make a statement, and it has to be offered against them at trial. It's a statement offered against party or a statement by party opponent. And you can see some of the landscape of some of the options we have for it. Of course, the top line, the definition, it belongs to the opponent. We've seen the proponent can embrace how it's not hearsay, or as we're going to get to in other videos, how they can embrace all the exceptions of 803, 804, and the residual exception of 807. And we talked about some of those arguments they can make in the middle here, where it says Porter's top 5. Some of those arguments that have to do with why it's not offered for truth of the matter asserted. We're talking about this middle row all the way to the right, the times when things are not hearsay because they're defined as not hearsay 1D. And there's a couple of them. We're focusing in again today on this last one: statements by party opponents or statements offered against parties. So that's essentially the foundational requirements of this rule. The first one, 801D2 capital A, is the easiest. Look for statements. Look in your fact patterns. Look in the multiple choice that are given to you. Look for statements said by a party. That's it. The declarant equals a party. The declarant is one of the two parties oftentimes. In the caption, are they the plaintiff? Are they the defendant? In a criminal case, is it the prosecution or the criminal defendant? And who's offering at trial? Who's presenting the evidence at trial? It could be through a document. It could be through a witness. But who's actually at trial presenting the statement? So if we look very crudely at the caption for a case, you have party 1, who happens to be the plaintiff here, party 2, that happens to be the defendant. It doesn't really matter. The crude analysis, especially for statements by party opponent, is who said it. So if party number 1 said, I love peanut butter and jelly, right? I love P&J. Then the analysis is over. The foundational requirement are said by a party. That's one foundational requirement that's met, so long as it's offered by party 2. If it's offered by the party opponent and said by a party, said by party 1, offered by party 2, it qualifies under this rule without any analysis, at least under hearsay, any analysis as to what was said. It doesn't have to be an admission. It has to be said by a party, here party 1, offered by party 2. Same thing goes. It is the same rule if all of a sudden party 2 has some other statement. Party 2 says, in this case, out there in the world, they are the declarant. Party 2 is the declarant and said, I love tuna fish. I love tuna. So they say that. They are the declarant. Party 2 is the declarant. Note that if party 2 at trial wanted to present its own statement, if party 2, through witnesses, through evidence, through whatever means they can at trial, wanted to say, I have said, party 2 has said I love tuna, they wouldn't be able to do it. It doesn't meet the foundational requirement. It needs to be said by a party and offered by a party opponent. So it only works here. I love tuna can be presented at trial from party 1. offered by a party opponent, said by a party 2. So that's the analysis. It just has to be two foundational requirements. This is why it's one of the easy ones, but often overlooked in essays and as a path to overcoming hearsay for the proponent. Was it said by a party, offered by the party opponent? Initial part of the rule. It gets one layer more complicated when we talk about the subparts that follow. How may we attribute statements to parties? That is, when folks that say things out in town, people that are declarants out there in the world who are not the party, but we are trying to attribute it to someone in the caption. We're trying to attribute it to the plaintiff, to the defendant. So they didn't say it in these instances. With 801 D2, capital B, capital C, capital D, and all the way to capital E with conspirator statements, the party didn't say it. We're trying to figure out a way to say, let's attribute it to the party as if they said it. And again, it's still offered by the party opponent. So let's, again, offered by the party opponent, that's still the foundational requirement. Now, instead of said by 801 D2 capital A, it's said by or attributed to. And here's the rules. You see party's own statement. It could be adopted by the party. All that means is, sometimes we prepare declarations for people that they sign, or sometimes we say things in front of someone that they say, I agree, or they nod along. Well, those instances, they may not have said the words, the quotes may not have come out of their mouth, the party may not have been the one that actually said it, but they've certainly adopted the statement of others. We think that's fair to attribute to them, so long as offered by a party opponent and fairly attributed to them as an adoption under 801 D2 capital B, we're fine with it. The same thing when we authorize someone. I think this one is clear. When we authorize someone, if I say to my public affairs officer as the president of a university, go out there and make a statement on this controversial issue of the day, I have authorized that person to speak on my behalf. I've authorized that person to speak on the behalf of the university. So it's as good as if I say it. It is fair to attribute it to the party as if they said it, so long as offered by a party opponent, that same party 1, party 2 analysis, it's fine. And the more controversial or complicated ones happen with subparts capital D and capital E. That is, we'll let employees sometimes, agents sometimes, attribute statements to companies, for instance. If you've offered a statement during and within the scope of your employment, it's as if the company said it, right? If we send, again, our speaker, designated speaker or designated press correspondent out before the press to offer a statement on behalf of the company, not only have we probably authorized them as to subsection capital C, but they're probably an employee. This is during their employment, and it's something that we authorize them to do. So you can see sometimes some agents, some employees, offer statements that are attributed and fairly attributed to parties so long as offered by the party opponent. And a more complicated one and a more controversial one, frankly, has to do with conspirator statements that we'll save for a separate video. But this too is a time when someone outside the caption, someone who is not a criminal defendant at trial, but is affiliated through conspiracy rules, affiliated with the defendant, someone out in the world says something that can be attributed to the defendant who's in the caption, so long as offered by the party opponent, most often the prosecutor. So you look at it here. We have party 1 versus party 2, again, caption. We know the easy way. If party 1 says something, party 2 can offer it. If party 2 says something out in the world, party 1 can offer it. We know statements against parties, statements offered by party opponents. We understand that. But now we're talking about, as you see my friend Chris here, you're talking about someone that says, I love ham and cheese. He's not a party. Chris here is not a party, and it is his statement. He is the declarant. So if we're going to use these rules, we're going to try to figure out how we can attribute Chris's statement to a party. What if he were saying that and it was adopted by party 2? Well, that might be okay. If he said, I love ham and cheese, and party 2 nodded along or said, me too, it could be as if party 2 said it. So then it's the equivalent of said by party 2, attributed by party 2, and it would be admissible so long as offered by party 1. What if party 2 authorized Chris to make this statement, I love ham and cheese? Well, then that too could be the equivalent as if party 2 said it. They still can't introduce it themselves. It still has to be offered by the party opponent, party 1. And what happens if Chris was an employee or Chris was in a conspiracy with party 2? These two are ways that it could be fairly attributed to party 2. So think about it. That clear rule, if it's said by a party, it can always be offered by a party opponent. Stay clear of the bad label of admissions for these rules, and you should be okay.